As I mentioned earlier, we're now 2 years and 2 months in, or 2 years and 1 month into the lawsuit. SEC filed suit against us, saying that our sales of XRP represented sales of unregistered securities.
Are you one of the many sitting on the edge of their seats, about to fall off while waiting for a ruling on the Ripple versus SEC case? If so, you're in the right place. For almost 3 years now, the XRP community has been awaiting the judge's verdict in the most talked about legal battle in the crypto space today. What is the newest development in this case? At the beginning of this month, the ongoing legal dispute between Ripple and the U.S. Securities and Exchange Commission, SEC, continues to drive uncertainty in the crypto community regarding which party will come out on top and the overall impact on the industry. Adding to the drama is the speculation surrounding when presiding judge Annalisa Torres will deliver the summary judgment. Yes, the immense pressure of putting an end to this almost controversial legal battle falls on the shoulders of Judge Annalisa Torres of the Southern District of New York. Initially, speculation was that the case could be resolved by the end of Q1 2023. However, pro-XRP lawyer John Deaton has suggested that interested parties keep an eye on the first week of May, as he predicted that a summary judgment will be delivered on that date. This adds to the prediction that Ripple CEO Brad Garlinghouse, who expects the case to be summed up in the first half of 2023, said. However, it's pretty obvious by now that it was a misprediction. Notably, Ripple has recently commented on the potential summary judgment date in its Q1 2023 quarterly report. While Ripple anticipates that the matter will be resolved sometime this year, the company recognized that it ultimately remains up to the court to make the decision. In the said quarterly report, Ripple also highlighted that one of the SEC's expert opinions on the reasonable expectations of XRP purchasers was stricken from the court record, along with another SEC expert opinion on determining the cause of XRP price changes. This move is significant for the ongoing legal battle as it narrows down the issues that will be considered in the summary judgment. It is also worth noting that Ripple CEO Brad Garlinghouse previously expressed their willingness to settle, but that the SEC and its chairperson Gary Gensler's view that almost all crypto is a security puts a sudden stop to their intent to come to a settlement. In fact, Ripple has criticized the U.S. regulatory approach to the crypto industry, stating that the focus has been on regulation by enforcement instead of clear rules. The company cited examples of enforcement actions, including the SEC issuing Wells notices to Coinbase and Paxos rather than creating regulations. You may know this already, but for context, the SEC sued Ripple and two of its executives, Chris Larsen and Brad Garlinghouse, for allegedly offering unregistered securities in the form of XRP. The SEC has faced criticism for its lack of clarity on what it considers security, with the ongoing Ripple case expected to bring more clarity. Despite repeated questioning, Chair Gary Gensler has yet to provide a definitive answer, including on the status of Ethereum ETH. For now, Ripple is currently seeking the unsealing of the Hinman speech documents, which may shed light on how the SEC initially classified digital assets. In line with this, while ruling for the Ripple Labs legal brawl with the US SEC is expected to be announced soon, attorney Jeremy Hogan has dropped an interesting update on a pertinent issue involving the market regulator. In an early May tweet, Hogan highlighted that Judge Torres previously rendered a verdict against the SEC in a matter involving mining from Rio Tinto. Interestingly, the SEC filed an appeal against Judge Torres' decision, hoping for a better outcome. However, according to attorney Hogan, the appellate court upheld Judge Torres' decision. The lawyer said in the tweet, "I was just reminded of a case in which Judge Torres ruled against the SEC on a key issue. The SEC appealed and the appellate court upheld Judge Torres. SEC v. Rio Tinto, just don't ask how long the whole process took." Attorney Hogan then supplied a page from Morrison Forrester's 2022 article in which the case was cited. According to the article, Judge Torres determined that scheme liability does not arise where alleged misrepresentation or omissions are the sole basis of such claims. According to the details, the SEC alleges that Rio Tinto failed to supply accurate information regarding the valuation of its coal mine acquired in 2011. Following the said tweet, some XRP community members have begun asking relevant questions concerning the case. For instance, a Twitter user, Neil Cox, asked the attorney if Ripple could move on with its business immediately and also permit Coinbase to relist XRP if the judge rules in favor of Ripple and the SEC files for appeal. While Hogan agreed that Ripple will move forward with its business, the attorney highlighted that there are no guarantees as to what Coinbase will do. According to him, Coinbase has been showing signs of inconsistency. Interestingly, the update comes soon after rumors that the SEC and Ripple may be reaching a deal. Even though the update has generated a lot of opposing opinions, the possibility of a quick resolution has further energized the XRP community. But first, why is this case such a big deal? It is important to point out that the ongoing legal proceedings are expected to have a possible impact on Ripple's business and on-chain metrics. However, despite this uncertainty, Ripple has maintained strong on-chain activity in the year's first 3 months. In fact, volumes increased by 9% to 116 million compared to 106 million in the previous quarter. Additionally, decentralized exchange DEX volumes surged 34% to $115 million compared to the previous quarter. Now, listen to this. There appear to be implications of a possible victory for Ripple. A possible victory for Ripple against the SEC could have significant implications for the cryptocurrency industry. Consequently, a favorable ruling for Ripple could result in increased regulatory clarity for the cryptocurrency industry. This could help establish clearer guidelines and rules for companies and individuals to follow when dealing with digital assets. Additionally, a victory for Ripple could lead to a more relaxed regulatory environment for digital assets. It could also provide more clarity on what constitutes security in the context of cryptocurrency. So, when can we expect the win? At a recent fintech summit in Dubai, Ripple CEO Brad Garlinghouse shared that the case could reach its conclusion within the next 2 to 6 months. However, top lawyer Bill Morgan thinks otherwise. Pro-crypto lawyer Bill Morgan, known for his outspoken opinions on Ripple, XRP, and the SEC, responded to Garlinghouse's statement. Morgan concurred with Garlinghouse's prediction, stating that the resolution of the case is likely to take place within the same time frame and could even be resolved as early as next month. Morgan took to Twitter to share his thoughts. He said in a recent tweet, he said 2 to 6 months. That is likely to be accurate, but it could be next month, referring to Garlinghouse's statement. He also suggested that Garlinghouse's prediction may have been based on information provided by Ripple's legal team, giving it more credibility than other predictions. Meanwhile, pro-Ripple lawyer John Deaton has been providing updates in the Ripple Labs vs. SEC lawsuit, with most of his comments favoring the blockchain company. In his recent post, Deaton said digital assets including Ripple are not securities. However, they can be considered as such when traded in the primary market. While maintaining his position that Bitcoin and Ripple are not securities based on the Howey test, Deaton observes that they may be sold as such under certain conditions. In this case, the SEC would have to examine each transaction in both the primary and the secondary markets. According to him, any interpretation that tokens are investment contracts is false, and this has not been contested by the SEC. In the SEC versus Library case, the judge stated that secondary sales of Library are not in any way considered security sales. For now, Garlinghouse, just like most of the XRP enthusiasts, stated that he is very bullish about the crypto ecosystem in the long term, as its utility and problem-solving abilities increase significantly. It is no secret that XRP currently has a bearish sentiment and has fallen by 6% in recent days to trade around 42 cents. The asset could likely reach its previous all-time high of $3 when it emerges victorious in the lawsuit. As you may know, the outcome of the court case between Ripple and the SEC may affect the cost of XRP. If Ripple wins the case, it could potentially result in increased adoption and demand for XRP, which could lead to a rise in its price. According to data from MarketCap, the XRP coin is currently trading below $1 at around 43 cents. With the growing sentiment surrounding the possibility of a win for Ripple, that the XRP coin will eventually touch $1 is a reality that cannot be ruled out. For now, all we can do is sit back and relax with our nails dug on the couch while awaiting the result of this case. Make sure to be updated on any developments in the case.